He admitted also that he shared a table with the deceased together with the second, third, and fourth accused. He also agreed with the prosecution's evidence that the deceased drank Tusker Light beer, went to remove his vest. He said that when the deceased collapsed, he rushed him to he stated that his family, he was a close friend to the deceased as they had known each other for many years, and that he would not have been capable of poisoning the deceased. He testified that he had known the deceased for over 5 years as he used to work for him. He further testified that on the material night for a drink which was opened for him at the table, that he went to room it, he collapsed, and they took him to Thika nursing home, that he also informed the deceased on the same table. He stated that he had no motive to kill the Andrew Wainaina, denied poisoning the deceased. He testified that he worked part-time at Porkies as the assistant events manager, that on the material day he was with the fourth accused, joined them on their table, that the third accused further stated that the deceased, him, as the member of parliament for Juja constituency, that the deceased sat between the first and second accused and ordered. The third accused further testified that the fourth accused came back after 10 minutes and he left the table, and when he returned from answering his phone, he found the table empty and that there was some liquid on the floor. That the fifth accused told him that the deceased had fainted and had been rushed to hospital. He testified that he worked in Porkies Club as an event organizer, marketer, and MC. That prior to the day, he had never interacted with the deceased, and he only knew of him as a politician. The fourth accused stated that the first person on the table was the third accused, that the table had not been reserved, that they were joined later by the second accused, and that the deceased joined them, that the deceased even bought him a drink. The fourth accused testified that he did not buy the deceased any drink or touch his glass, that at some point he left the table and went to his office to work. The fourth accused narrated how they rushed the deceased to Thika nursing home, and that when he went back to the club, he found the table and the bar had been cleaned. The fourth accused testified that he went to the upper bar where he stayed until 3 a.m. and he later went home. He denied having had any poison. The fifth accused, Esther Ndinda Mulinge, denied poisoning the deceased. She testified that on the material day, she worked as a waitress at Porkies. She testified that around 8 p.m. she served the third and fourth accused persons with their drinks, that later the second accused arrived and the deceased followed soon afterwards. She served the deceased, that when she went to serve the deceased, he told her, ngoja kidogo. That Martin went and talked to the deceased briefly, and then the deceased ordered for 1 cold and 1 warm Tusker beers. That she went to the counter and bought them and served him. The fifth accused further stated that everything on the table fell, and she was the one who cleared and cleaned the table. It was her testimony that the death of the deceased was announced in the upper club after she had finished her shift. She checked out at 6 a.m. and went home. The sixth accused testified that on the material day at 9 p.m., she went to Porkies to look for change for 1,000 shillings, that she went to the M-Pesa stall, which was downstairs, that she saw the first, second, third, and fourth accused seated on a table. She greeted the deceased and proceeded to get change at the cashier. She stated that she bought the deceased 1 bottle of Tusker Light and handed it over to him. That Phyllis, PW9, sold her the Tusker Light and she gave it to the deceased in the presence of the first, second, third, and fourth accused persons. She said then she talked to the DJ and left almost immediately. That she was not present when the deceased collapsed, as she had already reached her house. She said that the drink she bought the deceased had not been opened, and that she bought the drink as a gesture of friendship. There is judicial precedent on how the courts have applied circumstantial evidence in poisoning cases such as the present one. In Bernard Kungu Karaoke versus Republic, the court relied on circumstantial evidence after analyzing it. In this case, the prosecution evidence did not show that any of the accused had the poison cyhalothrin in their possession. However, that alone would not exonerate the accused if there were other circumstantial evidence linking them to the poison. To hold so would be tantamount to saying that an accused would be acquitted purely on the basis of a missing murder weapon. Poison is a chemical murder weapon, and the principle that failure to find a murder weapon was not a ground for acquittal should equally apply, for to hold otherwise would be a failure of justice. In this case, therefore, I rejected the proposition that the accused would be acquitted if they were not found in possession of the poison. Both the first and second accused had knowledge that the deceased was coming to the club that evening. This was the evidence of the deceased wife, PW1. Firstly, she overheard a conversation between her husband and the first accused, and before leaving the house, he informed her that he was going to Porkies Club to watch Formula One with the first and second accused. Both the first and second accused admitted in their respective defenses that they received a call from the deceased and they were expecting him at the club. The first and second accused were therefore aware of the deceased's plans of going to Porkies. They did meet, sat at the same table, and had drinks as they watched the Formula One race. It is the view of this court that the first and second accused had sufficient notice for any good or bad plan for the deceased. There was evidence both from the prosecution and the defense that the first accused and the deceased were friends. There was evidence also that the second accused and the deceased were friends and that their respective families were family friends. That the second accused, Christopher Lumbasio, used to run errands for the deceased, and the deceased had even bought a truck for him. Judy Thuo, the deceased wife, told the court that the second accused and his wife had participated in the deceased brother's wedding and joined the family for a drink in the evening. Lawrence Nganga confirmed that his brother Thuo invited a few of his friends for drinks at Nakumatt Waitress. With respect to the first accused, PW1 acknowledged that he was a friend to her husband and she had met him twice or so when they visited Porkies Club. It is safe for this court, therefore, to conclude that the first and second accused were well known to the deceased and that they were friends. If they harmed him, then it was a case of kikulacho ki nguoni mwako, which means that those who harm you would be closest to you. Looking at the circumstantial evidence as a whole, it is clear to this court that the first, second, third, and fourth accused sat with the deceased throughout the evening. There was no evidence that they left the table at any time. They had the opportunity to see whether the drinks served by the fifth accused were truly not open prior. They had also the opportunity to tamper with the drinks. By the acts of omission, they entertained their friend while he ingested the lethal drinks. The third and fourth accused stated that they were not personally known to the deceased. The uncontested evidence is that they sat at the same table. In their separate defenses, they state that they were not really in conversation with the first and second accused and the deceased because they were concentrating on working on an online poll for the club. The question then is, why were they seated with their boss, the first accused, and his guest, the deceased? By their own admission, they were not socializing with them. Their presence at that particular table was suspect. They had an opportunity with the first and second accused to tamper with the deceased's drink. The third accused said in his defense that he was not present at the table when the deceased collapsed, as he had stepped out to make a call. That when he returned, he found the table empty and learned that the deceased had collapsed and had been taken to hospital. This, to the mind of the court, was not a credible defense because there was evidence of a commotion when the deceased fell, and the same would have attracted his attention. The evidence against the fifth accused was that she was the waitress on duty who served the Tusker Light beer to the deceased. As already found, traces of poisoned cyhalothrin was found by PW15 in the said bottles. It was the same poison that was found in the deceased's liver and stomach and which caused his death. The question then is, who laced the drinks that were served by the fifth accused? To delve into this question, have considered the evidence of Phyllis Wanjiku Ngugi, PW9. She said that she worked as a cashier, and on the material date, she reported on duty at 10. She testified that Ndinda, who is the fifth accused, was on duty from 4 p.m. together with Sam, the supervisor, and Lucas, the bouncer. That she sold alcohol from a counter which was secured with a metal barrier. She said that around 7 p.m., Karanja and DJ, who was a DJ, and VC4th, who was the MC, came and sat near the counter. That around 9 p.m., Dinda, fifth accused, bought a brown Tusker Lager bottle and said it was flat. That she checked to see the table where the beer had come from, and that is when she noticed Lumba, who is the second accused, sitting on the table. PW9 exchanged the beer with a good one, and she said that at that point she noticed the deceased. She gave details of the deceased as a person who preferred black label whiskey or Tusker Light, that he would usually drink from a whiskey glass, and that the wine and whiskey glasses were kept within the M-Pesa shop. From the evidence of PW9, it is clear that she was the one who picked the beers from the fridge and counter respectively and gave them to the fifth accused. The question then is, did she pick any random bottles or particular bottles to satisfy the order of the deceased? And conversely put, was the fifth accused aware of the particular bottles to be served to the deceased, or was she just innocently going about her duty? Other than denying any role in the death of the deceased, the fifth accused did not have an explanation on the drinks she served. While she did not have to prove her innocence, how she handled the drinks and whether they were tampered with was something and how they were tampered with was something within her knowledge. She failed to rebut the evidence against her. This court finds it perplexing that PW9, who seemed to be in control of the alcoholic drinks and dispensed them from a secure counter, was not charged along with the fifth accused. In the court's mind, she owed an explanation of how she had handled the drinks that she said were in her custody as a cashier. With respect to the sixth accused, the uncontroverted evidence is that she walked into the club, saw the deceased seated with the first, second, third, and fourth accused, waved at the rest, and greeted the deceased. She then proceeded to the counter, bought one Tusker Light, and personally delivered or served it to the deceased. In her defense, she stated that she bought the deceased a drink as a sign of friendship. She explained that she bought for him alone, as that was what she could afford. I have examined the prosecution evidence with respect to the conduct of the sixth accused alongside her defense. She stated that earlier on the material day, she left Thika for Zimmerman to have lunch with her family. That some minutes after 8 p.m., she took a matatu and headed back to town. That she arrived at around 9 p.m., went to Porkies to look for change for 1,000 shillings, which she needed for her onward journey home. She said that she bought a drink so as to get change, yet at the same time, there was evidence that she was a regular customer, meaning that she would have gotten the change anyway without having to buy a drink. When she walked into the bar, she hugged the deceased, bought the drink, handed it over to him, and was on her way out. Was her hug the Judas kiss? My appreciation of the prosecution evidence against the sixth accused and our own admission that she walked into the bar, bought the Tusker Light, and handed it to the deceased and immediately left demonstrates that she had ill intentions on the material night. The fact that the drink turned out to be lethal clearly links her to the death of the deceased. I have reconsidered the entire evidence to see if any of the accused had the motive to kill the deceased. From my analysis of the evidence, there was no motive discernible from the prosecution evidence on motive. I have keenly considered the evidence in respect of the fifth and sixth accused to discern any motive to harm the deceased, and none was discernible. However, one cannot be said not to have an ulterior motive when they have clearly served a harmful substance. It is to be remembered, as already demonstrated above through judicial authorities, that motive was not a necessary ingredient for the offense of murder. Flowing from the above, it is my finding that the circumstantial evidence produced by the prosecution was sufficient. It was not based merely on suspicion. The circumstantial evidence has clearly linked the accused to the unlawful death of the deceased through the administration of poison. They may have acted in concert with others, not before the court. It is my finding, therefore, that the first, second, third, and fourth, fifth, and sixth accused were linked to the unlawful death of the deceased. As to whether the 6 accused persons acted with malice aforethought, in our law, Section 206 of the Penal Code defines malice aforethought. It includes the intention to cause the death or grievous harm, the knowledge that the act or omission will probably cause the death, and includes an intent to commit a felony or to facilitate flight or escape from custody. In the case of Tubere versus Republic, the duty of the court in determining whether malice aforethought has been established is to consider the nature of the weapon used, the manner in which it is used, and the part of the body injured, the conduct before, during, and after attack. This court agrees with the submission of the prosecution and the victims that whoever laced the deceased drinks must have known that such an act would probably cause the death of the deceased or cause him grievous harm. This is demonstrated by the choice of the lethal chemical cyhalothrin. In the final analysis, it is my finding that the prosecution proved its case against the first, second, third, fourth, fifth, and sixth accused to the required legal standard. Each accused is therefore convicted accordingly. As I conclude this judgment, I wish to express my gratitude for their patience during the pendency of this trial, which must have caused great anxiety. The delay, which is regretted, was occasioned by a number of factors. This is the judgment of this court delivered this Nairobi. Apply copies of the judgment after editing. I think court assistant can be available maybe on Monday. Yes, sir.
As an example, you is a great departure from the Apostle Justice. having regard to the legal authorities, I find the evidence adduced by the prosecution, having regard to the fact that which the parliament put the accused forces.
Counsel, if I may interrupt you, appeal.
I appreciate your honor. I intend to make an appeal to the Court of Appeal. I believe I speak on behalf of all the accused persons when I say to you, they have religiously complied. To my present surprise, some of them even phoned me to tell you when the matters come very, very clearly that they are law abiding citizens. The trial of this matter has taken unusually long. Economically, that in the capacity of and I ask for your attention so that we may be given bail by the Court of Appeal. And next in order that they continue to be bail until further orders of the Court of Appeal. That has already 20 terms of this country. Justice for everyone. Rule of law to be upheld. Human rights to be observed. Independence of judges. Training. All these people here are young people. They have nowhere to go. Kenya is a country that we thought nothing as ridiculous as that type can be done. They will not finish and run this people there. The old norms that are because of people victim. As I've seen, most respect to this world. The chances of them being acquitted are high. This court stands for a lot. We as advocates here stand for. There's something else that I would like to mention in the fourth part of my argument. Corona COVID-19 has not died completely. It is still vibrant. If there is at least once every month, just to find out, to rather visit the prisons at least once every month to find out what's going on in prison. That practice has been abandoned. And it is easy to write and say the truth before truth. Partly because women judges rarely go to prisons, current prisons, to find out the person. Our prisons are heavily contested. They are very heavily contested. And the prisons are very heavily contested.
Make it very brief. It's been a long day.
Trust authorities from the own voice to the ministry people could not have been responsible for killing one person. Poisoning is something that can be done very secretly. I think you cannot hold prosecution proceedings and process that kind of.
What was your name again, Counsel? Mr. Mubu.
On behalf of the family, ours is to thank this honorable court for giving a part closure to the family, even as the defense proceeds on appeal. We do thank all participants in this court, Senior Dr. Camino and the defense counsel. Together.
I need to give, which is sentence hearing. And before we get to a sentence hearing, do we have probation going to make a response? Probation officer to file. And how long do probation officers take in this jurisdiction to come up with pre-sentence reports? Can they take a week, a few days?
No, 2 weeks, remember, to the high side.
Why would do they?
They can even be within less than 1 week.
Can they take in hearing?
So we can take it immediately after 7 days.
Immediately after the 7 days. Where does that take? Where does that take?
I didn't hear what you said.
Yes, I was just asking myself.
You were just talking, my friend.
Oh, what have you said? Can you take this? Second or third of May? Take the 3rd of May.
Your Honor, let me just check my diary. I'm a full-time lawyer.
Alternatively, could you do
Your Honor,
submissions?
2nd of January, 2nd of May, the suits me. I can check 2nd of May.
Can you take 3rd? Can you take 3rd in the morning?
Oh, the 3rd in the morning.
3rd in the morning.
Yeah. Your Honor, may I say something? We have this cultural hearings and so on.
Yes, so what you will be addressing the court
I will
about
address you already.
will be
I will not
on
do that.
sentence. Okay.
I'll address you. I'm clear of what I would like to say for clients. Tell me what I would like to do.
Prosecution, can I? Yes.
You release them on the phone so that I can have a chat with them in my office. I can tell you what they would like to say.
Application for bond on Monday. Just write your response for the court to have it on Tuesday. And then,
That's on side.
and then counsel, and then I will give my ruling on the day we come for sentence hearing.
Your Honor, that is, sorry.
And the accused will be remanded where? Prosecution counsel?
said to you, I'm a full-time lawyer. I go to Mutaika police station. Some of them even tell me very privately, I'm thinking of committing suicide. And I have to tell them that, man, the world will say that you're a coward, you're an idiot, that you have committed suicide. Don't commit suicide. People are living in very horrible conditions. And we have got a kind of media in this country which does not even go to the prison to find out how people are living there at all. People are living in deplorable, despicable conditions in prisons in Kenya. Rise to the occasion as a judge and make an order that people can be taken to police stations. That's all. So can I come here, on Monday, assuming?
No. This is not my jurisdiction. It's me. In open court, that will be on 3rd of May 2024.
On what day?
3rd of May 2024 at 9 a.m. when we will be doing the sentence.
I thought you said 11 o'clock.
Or did you want 11?
11 o'clock, yeah. I do virtually. I'm up.
11? The other counsel? Also, yes. Who the prosecutor? Because she has listened to your prayer. For any other outstanding issue.
Shocking. It is shocking.